We now open the floor for interactive session, which will be moderating by Dr. Sajida Bashir.
So it's my pleasure to now open the floor to questions and answers. We have about 20 minutes, and I would really encourage young people in this audience to ask questions. And we also have people online. If there are questions, please put them in the live chat, and we will try and respond to them. So anybody who wishes to ask a question?
Now over to esteemed Justice Nariman. I deem the basic structure of our constitution cannot be changed. It has been clearly stated.
That's the other book I've written. You can carry on.
No, it has been clearly stated in the preamble of our constitution that India is a sovereign, socialist, secular, democratic republic. Now that preamble denotes the basic structure of our constitution, which cannot be changed. Please give a briefing on it.
Yeah. Can you all hear me? This mic on? Just put it. Can you all hear me? Okay. There's another book I have come out with recently, which is exactly this, basic structure. Now, the reason why our courts evolved basic structure, and it was a 13-judge bench in Kesavananda Bharati's case, by a razor-sharp majority, 7-6. The reason why they evolved it was obviously because constitutional amendments were getting out of hand. This is a constitution that you can amend very easily. For some reason, the founding fathers thought that they did not really get everything right, and that they ought to wait for an elected parliament, which happened in 1952, to have a re-look at the constitution and then change it to suit India's needs. That perhaps was their thinking at that time. That was fine. But then if you wanted to push through something which would, for example, change or convert a democracy into a dictatorship, you could do one very simple change which didn't even need ratification by the states. You could just prolong the life of the Lok Sabha. Now, if the Lok Sabha life is 5 years, just replace it by 15 years, so that the ruling party goes on for another 10 years without elections. That you could do very easily, that did not need ratification. And that you can do by a simple 2/3 majority in parliament. Mind you, theoretically, you can do it with less than half. Why? You have to have a minimum of half, the house. If you imprison the other half, you've got half anyway. And then you require a 2/3 of that half. So with 1/3, you can actually change the constitution and completely deface it. Now, faced with dilemmas like this, ultimately, thank God, a majority of 7-6 said, no, this cannot be done. This has to face a further test in courts. And it's a substantive test. That have you done something which has damaged anything which could be called the basic structure or an essential feature? And no sooner did they lay it down than the great 39th Amendment came, by which the Prime Minister and the Speaker were put above the law. And something amazing was said in that amendment, which is that you will apply no law to a particular judgment of the Allahabad High Court when you decide the appeal. You'll just allow the appeal. Now, if things like this could be passed as constitutional amendments, of the 5 judges, 4 were minority judges in Keshavananda Bharati when they heard Mrs. Gandhi's case. 4 of them applied basic structure to strike down this constitutional amendment. So that, fortunately, has come to stay, no matter what some politicians at some point of time keep saying. Yes.
Thank you. We have a lot of young people here, law students also and others. Is there anybody who would like to ask a question from?
Sir, my name is Sajid Kumar P. My question is, in this day of digital era, means in this day of Elon Musk, Mark Zuckerberg.
Sorry, I can't hear
Just
very
speak
well.
up, I can't follow you.
Yeah.
Come here,
In this,
come in front.
in this day of digital era, is there any possibility of their updation of that preambles in this relevant in this nowadays?
Sorry.
In this day of digital era, means now the days of digital era. Is there any updation possible in that preambles and like that?
No, there's no such. No. Not to my knowledge, no.
No, digital. Okay.
No, just hang on 1 minute. Okay. Any other question? Yeah, please. Could you give the mic to him, please?
Sir, it was a privilege listening to you directly, and
Thank
I
you.
should, of course, thank the Trust for bringing you to Thiruvananthapuram. I listened to whatever you said very closely, but one thing which strikes me is there are now societies, nations in the world, where a majority of people do not believe in any religion, and they do not seem to be worse off for it. The kind of values that you described as based on religious principles
Yes.
are being practiced by these nations which do not, avowedly or publicly profess or practice a religion, whereas in our country we know for a fact that we are very, very overtly religious. So I'm just thinking whether we are having too much of religion,
Right.
which is working against the higher principles which you spoke of, which is there in the books. And I remember Vivekananda saying about Hinduism, no religion in the world, speaks of the dignity of man in so lofty a strain as Hinduism. And no religion has trampled upon the poor in such a, drastic manner as Hinduism. Something to this effect. This is my...
Yes. May I answer you immediately? Soviet Russia and communist China did not believe in religion. I'm just telling you as a fact. The greatest mass murderers in history were Comrade Mao and Comrade Stalin. Now, why were they the greatest mass murderers in history? Because there were no moral constraints. First thing that a religion teaches you is moral constraint. Now, there may be the bad side of religion which you need to tackle, like Swami Vivekananda. And therefore, he tried to reform the bad parts in Hinduism. But you don't throw the baby out with the bathwater. And the baby is very important. Now, if the baby has nothing to do with moral constraints, then it's up to you to do as you feel. Some may follow moral constraints on their own by being atheists. Now, for example, the Jains are atheists. But look at the rigorous moral constraints which they live under. And in fact, it's such a fantastic faith because though they don't believe in God, they believe that you cannot cause suffering to any living creature. They go way beyond man, way beyond the other great faiths. So you could be atheistic, but at the same time you have to have moral constraints. If you teach moral constraints as a central part of whatever you are, no problem.
Okay, there's one question there, and then there's a question there, and then
Can you
here.
turn this fan, please?
Please go ahead.
Turn it
Yeah.
around. I don't want it on.
My question is that the religious dogmas, they are so strict like the basic structure.
Yeah.
And they promise a life after beyond death.
Yes.
So they are willing to die and kill for it.
Yes.
So how can we make people more reasonable in their religious beliefs?
We don't set out to make people anything. We set out only to do whatever we think is right and to live and let live. If the other gentleman believes in something, fine, let him believe whatever he likes. He has complete freedom to believe what he likes. So long as he doesn't impinge upon somebody else with violence, that's all. Violence is the basic thing according to me. So long as you believe whatever you like without violence, up to you entirely.
Okay, just 1 minute. I think there's a young man there. Could you speak and then I will.
To the Honorable Justice, at this current moment, what is the relevance of fraternity at the global stage, especially amid exclusionary actions taken by those in power?
Today, according to me, it is the single most important cardinal value which needs to be taught. Incidentally, the UN Declaration of Human Rights, Article 1 speaks of fraternity. The very first thing is fraternity. The spirit of common brotherhood. Now, where are we? My God. Where is brotherhood? There's only fratricide. Brother is only killing brother in the world. There's nothing like fraternity. So we appear to be following the exactly opposite path. The sooner we get onto this path, the better for all of us.
Yes, sir. Please.
Sir, thank you very much for that very thought-provoking lecture. I was struck by a couple of things in your lecture. The first was this reference to K.M. Munshi and this right to propagate. And then you also referred to the national flag and drew your attention to the wheel, Ashoka Chakra, which talks about propagating dharma. Now, I was wondering, why is it that the court does not really factor that in while debating this very seminal point that becomes a bone of contention of propagation. So what is it that we propagate? We talk about saluting the national flag every day. We acknowledge that. But why is it that even the judiciary seems to be forgetting something like this? That's the feel that I got from your lecture. Pardon me if I'm wrong. But why does this happen? That's my question.
What I tried to convey to you was that there is a Supreme Court judgment which needs to be corrected. The Supreme Court judgment says propagate has to stop at conversion. There can be no conversion. Now, what it forgets straight away is the concomitant right of the person to be converted. Now, I can follow any religion I choose. I can change my religion midstream, correct? And that's recognized by Article 18 of the UN Declaration, specifically. That you have the right to change your religion midstream and go. Now, if somebody persuades you to a particular point of view, how can you stop him? It's my simple thing. It's part of your right to freedom of speech and expression. So if I persuade you to a particular point of view and you accept, fine. Who am I to stand in the way? But if the persuasion happens to be with intimidation, with force, with brandishments of other kinds, certainly interdict. Nobody stops you. That's a misuse. But if you are converted purely by teaching you about a particular faith and saying there's a great faith to follow, come and join us, I see nothing wrong.
There's a question online, so I will read it out. But I just want to also add that I think the question of moral code is really essential, whichever religion or lack of religion there is. And that is really the final point. You can profess anything, but if you don't have basic morality, then you can justify anything also. So the question is, I'm not sure whether I fully understand it, but let me say it as it is. Now in this age of digital era, Elon Musk, Mark Zuckerberg, and so on, is there any possibility of amendment of the preambles in accordance with today's era?
It has nothing to do with these gentlemen. It has to do with the gentlemen in Parliament. Now, if the gentlemen in Parliament choose to follow something these gentlemen do, God alone knows what they choose these days, then fine, yes. But by God's grace today, no single party has that majority to tinker with the Constitution. By God's grace, again I say. Yes.
Yes.
Thank
sir.
you for the opportunity you given to me. I am Tirumala Satyadas, a devotee of Jagat Guru Swami Satyananda Saraswati. I have written a book, World is One Family, How and Why. We are all brothers and sisters, but we do not understand. To make us understand that we are related, love should be there in between. Now the religion, the most highest religion I say, Islam. I should take the rope, the chain, and control the world to make united. And India definitely, Mr. Modi, under Mr. Modi will help him, and we all live as real citizens of the united India. Thank you all.
Thank you.
Thank you.
Hello.
Okay. I think you had no, you didn't have a question.
Hello.
There's another question. Yes.
I have a question,
Who's that?
sir.
Yes.
I'm
go ahead.
Jain. I have a question. That is, the opening lines of our preamble starts with "We the people." Was it not very deliberate? Because even the American Constitution, if I'm not wrong, it started with "We the people," and then something was added to it, that is God, etc., faith in God. We never had this, and we do not want to have it. Is that not correct? That is one question that I wanted to ask. The debates, you know about it, what happened, and how Ambedkar and Nehru were able to prevail over the others in keeping it as "we the people." Another observation that I wanted to make about regarding what you said is, someone was talking about there are many countries which do not have a faith or religion of its own. We have the example of the Scandinavian countries, the happiest countries in the world. Of course, some of them are religious in the sense they don't show it outwardly, but they stand for something that is common to all, that is a welfare state system. What about we talk about cooperative federalism, but we don't give any importance to it these days. How is it that these countries that talk of collective security, or common security, I would say it, are able to survive even to this day with their concepts or ideology of democratic socialism? And the third one I want to ask you is, some of our judges, or while Chief Justice himself, while pronouncing judgments, talk of a divine intervention. What is this divine intervention? Which I don't understand.
All right. Let's start with the last one first. Whether with divine or bovine intervention or any other kind of intervention, if a judge delivers a judgment, he is violating his oath to the Constitution. You have only to live by your oath to the Constitution and the laws. And when you live by your oath to the Constitution and the laws, you certainly bring in your own morality. That's about as far as it goes. Now, to come to the other two parts of your question. The first part is a very interesting part, because though the US Constitution may talk of "we the people," when it was framed and when it came into force in 1789, it left out more than half of its own people. There was no such thing here. It left out the blacks completely. Blacks were in fact treated as property. It left out women completely. So there was one half of the white women left out. So it left out a huge number of people who down the road with constitutional amendments it sought to bring in. It took them God knows how many years from 1789 till 1865 to bring the blacks in, and much longer to bring women in, 1920. Now we had no such thing. So when we started with a clean slate and we said "we the people," we meant we the people. And what we gave to minorities, what we gave to pluralities, etc., showed that it reflected we, all the people. So that is the answer to the other part. Now, your second part, your second proposition, was that you have countries like Norway, Scandinavia, etc. Don't forget, very difficult every time I'm told, compare us to Singapore or compare us to Norway or you see, they have a monoculture. It's so much easier to push through something there. This is a land which is so diverse that, I mean, almost every 20 kilometers you change food habits, you change language, you change, it is so baffling and bewildering. How we function at all is something amazing, right? So never compare chalk with cheese. What Norway may do, Norway may well do. It's amazing that we do anything at all, is my answer.
Said there are several religious institutions which run so many educational institutions in Kerala. They accept capitation fee, they ask their caste, and they do not comply with the rules of reservation, and not even that of the Supreme Court judgment reservation for the physically disabled. What are the remedies?
Go to court and God help you.
Okay. I think there's a question at the back. Please go ahead.
Hi, before I start with my question, let me congratulate Dr. Jacob Alexander for presenting that 3,000 years of brotherhood in just 15 minutes or a little over, more than 15 minutes. Thank you. Now, Justice Nariman, my question is not related to anything that you've discussed today. It's from the striking down of section 66A of IT. And I'm an academic by profession. So this question is where through that striking down
will
of...
you allow her to speak? I can't hear her. Just a...
Through the striking down of that section, you probably, removed an unconstitutional section and bringing freedom of speech in online. But the recent development, probably post-2015, we could see a number of cases which are all branded as anti-government, anything that is written against the government. However, on the contrary, we could see a lot of followers are spreading fake news, right? They're using social media to propagate and spread a lot of bad things, but they're all sort of branded as free speech. So, however, to bring an academic perspective, recently that Professor Ali Khan's arrest, right, of Ashoka University, right, he was arrested without following any due course, just by putting a post which is read by any citizen or any educated person as a, an innocent, or probably it did not mean anything. But Supreme Court, while granting the bail, they called it as a dog whistle. However, recently, when they reconsidered the case, he was given a gag order that he could not write anything, online. But recently, they have eased the gag order. However, my question is, was striking down of the 66A with an intention of bringing free speech online, was it served its purpose? If not, what is the remedy?
Remedy is you bring me back to the bench. And I'm not being specious. Bring me back to the bench. You have to feel constitutional values, otherwise it's nothing. Yeah.
Is there another question? No. Any other questions from here? Yeah, please go ahead.
Let's make it the last.
So I'm a student of law, so this question is as absolute and simple as it is. So unlike other fields like medicine, engineering, biotechnology, and architecture, which are controlled by natural mechanisms or natural law, unlike all that, law is man-made. So, sir, I am a firm believer that if law is a problem, or if some problem has been interpreted or solved via law, it can be easily done with mere wisdom and common sense. So does that make the subject of law a bit more simple or a complex one? I would like to hear the views both from Alexander Jacob sir and the Honorable Justice.
I'll give you an answer immediate. The immediate answer is there's a very famous footnote in Justice Matthew's judgment in Indira Gandhi's case. And you'll find that footnote at page 520 of the Reporters, 1976 to SCR. Please go to it straight away. The footnote speaks of Lord Coke and King James I. And exactly this question was asked. James I asks his Chief Justice, why can I not preside over the King's bench? After all it requires is common sense. So Lord Coke flattered the King and said, of course, but, and the but was very important. The law consists of artificial, not natural reason. And because it consists of artificial reason, it requires long hours of study before you can even approach it. So therefore, I would advise Your Majesty, of course Your Majesty can do as he pleases, but never to preside over the King's bench.
All right. I think we've reached the end of the questions now, and I will